All right. Good evening, folks. Welcome to Friday night fun night on Kirk's Law Corner. Oh, hope everybody had a wonderful weekend. Oh, wait, it's Friday. Gonna have a wonderful weekend? We're gonna have a good weekend? Maybe. We shall see. Oh, tell you, been a busy week at the office. Long days, putting in the hours. It's been one of them days, one of them weeks. Actually, I'm gonna put this on real quick. That's a little warm under there. Actually, let's do it right there. Let's see. This is gonna work here. Okay. Okay, Facebook freaking out again. All right. Is it gonna work? Okay. Whew. All right. So I got a couple interesting things to share, which actually I'm gonna have to pull it off of this other computer so I can put it on the other one because it won't show up right. But we'll get it. Let's see. I gotta do what? Save. In. Let's see, where is it at? H. Okay, there we go. Had somebody in the Wednesday night workshop share a little something, and I'll share that here in a little bit here as soon as I can get this moved over. But I want to toss out there thanks to all the supporters out there for all the likes, the follows, the shares. Oh, actually, you guys are seeing everything I'm doing right now because it's in the way. And it's being a pain in the butt right this second. Let me put it in Idaho. Okay. Everybody got to see that over here on UBTube. Trying to save that over here because I left the flash drive at the office. The one that had it on there. Now I got to move it over to here. So everybody can see it. Right on. All right. So thank everybody out there that's doing the likes, the follows, the shares, because everybody needs to know, right? Bobby, I don't know what your problem is and why you can't comment on YouTube, but other people are commenting on there. I haven't showed it yet. It was only on the other one that was overlaying the screen, so it picked it up. But YouTube is better, huh? YouTube is better than Facebook, I guess. All right. Now I got it over here. Come on, where you at? There you are. We'll knock that down for a second. All right. And of course, when I go to screen share, it's going to mess it all up. But let's just do it this way. Okay, so we're going to have a little bit of, I don't know. It's fun for me, right? I don't know, it might be fun for some others out there. So one of the things here, where'd it go? There it is. All right. From the Chicago manual style here. Certain people that might be watching right now might want to really take good note of this, because this is part of the scheme, scam, and the fraud going on. Okay, we're looking at glosses in ASL. Now, ASL is American Sign Language. The written language transcription of a sign is called a gloss. Glosses are words from the spoken language written in small capital letters. Now, see where this is written here, woman, school, cat, would actually be in like the regular size lettering here. Alternatively, regular capital letters may be used like it is here, because it's hard to do that here. Although what I would do, I could do it like this, and I could change that font to like that. So see, that would be still, and we'll actually, if you look close in the Bible, a lot of times you'll see the word Lord is in all capital letters. You find that odd? Because I do. Because that's what we're talking about here. Alternatively, regular capital letters may be used. When two or more written words are used to gloss a single sign, the glosses are separated by hyphens. The translation is enclosed in double quotation marks. So right here's an example, right? The sign for a car drove by in proper English, quotation marks, is written as all capital letters, vehicle hyphen drive hyphen by. Now there's some other people out there that use this type of language, like full colon hyphen full colon hyphen hyphen full colon. They're talking in sign language, so they're full of crap. One obvious limitation of the use of glosses from the spoken written language to represent signs is that, pay attention right here, there is no one-to-one correspondence between the words or signs in any languages. Any, none. So this does not correspond to any language. None. Zero. It's a fraud. It's a sign language. It does not transpose into any other language. It's a fraud. So when we look at certain court documents, you will see all capital letters, and I'm not talking about just our names. I'm talking about like the state of Idaho, the 4th Judicial District of the, right? All of that stuff. It's fraud. It's sign language. It's not even proper sign language because it doesn't have the hyphens in there. But anybody who talks like that, the hyphen this and hyphen that, they're talking in sign language. That's not proper English. See, like it says here, one obvious limitation of the use of glosses from the spoken written language to represent signs is that there is no one-to-one correspondence between the words or signs in any languages. Source, the Chicago Manual of Style, 17th edition, page 665 and 666. Now, here's from Merriam-Webster's. Gloss 1b, a false and often willfully misleading interpretation as of a text. A false and often willfully misleading. Barshmew. Now, this here is Black's Law Dictionary, 4th edition, that I pulled out and put in there. Gloss, an interpretation consisting of one or more words, interlinear or marginal, which means in between the lines or over on the margin. An annotation, explanation, or comment in any passage in the text of a work for purpose of elucidation or amplification, particularly applied to the comments on the corpus juris. All right, so now here's the next one. Glossa, it's Latin, a gloss. Explanation or interpretation. The glossae of the Roman law are brief illustrative comments of annotations of the text of Justinian collections. That would be that Justinian deception, made by the professors who taught or lectured on them about the 12th century, especially at the Law School of Bologna. And where hence called glossators, fibbers. Oh, wait. These glosses were at first inserted in the text with words to which they referred and were called glossy. Interline areas. But afterwards, they were placed in the margin, partly at the side and partly under the text, and called glossy marginals. Okay, again, so it's little side text. A selection of them was made by Crus Cicius AD 1220 and 1260 under the title of Glossa Ordinaria, which is of the greatest authority. Now, here's a maxim of law. And I'm not even going to begin to try and speak that Latin. It is a poisonous gloss which corrupts the essence of the text. Again, these last three here are from Black's Law Dictionary, 4th edition. So actually, what's crazy here is I found online the Chicago Manual of Styles. Let's see. Does it have a, we should have the page numbers on here. Right there. I bet that's it. Oh, what? You want me to log in? Thought this was on for free. Uh-huh. Well, I guess not. What a bunch of BS. Oh, I guess I'll just, oh, wait. What was that? American Sign Language. There it is, Glossus and ASL. Of course, it's not going to let me to have it, but the gentleman that was in the meeting Wednesday night shared that right out of the book because he bought the book. So I asked him to type it in there so I could put it out here to share. And I did a little more research on it, and that's what I came up with. So now, one of the things I'd like to talk about, which is something that happened on Monday, right? A lot of you have seen those videos. And let's see, can I just go here? No. So we'll start with the latest first, right? Let's see if it's going to make me, yeah. So we're aware of the Sixth Amendment, right? That we have the right to the assistance of counsel. Because that's what it says as it is written, right? It does not say the right to a lawyer. It says the right to the assistance of counsel. Because let's read what it actually says. And to have the assistance of counsel for his defense. I mean, why would we even have a thing called durable power of an attorney in fact? In fact, it does make you the attorney. That's a private contract, and there shall be no law impairing the obligations of a contract. But here's the limitation right here. This is a right retained by the people. There is no subject matter jurisdiction for government. Because there's a period at the end of that. It doesn't say, and the legislature shall have the authority to make appropriate legislation regarding the assistance of counsel. There's no delegation of authority. There's no delegation of power here. And this is in the Bill of Rights. Remember, rights are the law. So, when we look in here, again, you have to take these things by reading between the lines, because I'm well aware, and some of you might be, of how the bar and the judicial branch has twisted things. Absolute. Oh, wait, I thought we didn't have absolute rights. But we do. Don't we? What? It's an absolute right to counsel. Well, let's start here. The records of neither the Congress that proposed what became the Sixth Amendment nor the state ratifying the conventions elucidate the language on assistance of counsel. Really? The development of the common law principle in England had denied to anyone charged with a felony the right to retain counsel while the right was afforded in misdemeanor cases. This rule was ameliorated in practice, however, by the judicial practice of allowing counsel to argue points of law and then generously interpreting the limits of legal questions. Colonial and early state practice varied, ranging from the existent English practice to appointment of counsel in a few states where needed counsel could not be retained. Contemporaneously with the proposal and ratification of the Sixth Amendment, Congress enacted two statutory provisions that seemed to indicate an understanding that the Sixth Amendment guarantee was limited to retain counsel by defendant wishing and able to afford assistance. Lie. And why is Congress enacting statutes on a right? There's no subject matter jurisdiction. None. By federal statute, an individual tried for a capital crime in a federal court was entitled to appointed counsel. And by judicial practice, the federal courts came to appoint counsel frequently for indigents charged with non-capital crimes, although it may be assumed that the practice fell short at times of what is now constitutionally required. State constitutions and statutes gradually ensure a defendant, gradually. So they fundamentally altered the right. Okay? That would be unlawful, would it not? Yeah. Let's see. Was retained counsel, but the states were far less uniform on the existence and scope of a right to appointed counsel. It was in the context of a right to appointed counsel that the Supreme Court began to develop its modern jurisprudence of a constitutional right to counsel generally. It's not a constitutional right. It's a right retained by the people. This is a right that came before the Constitution. See, our rights are long and descendant to the formation of the state, period. That's Hale versus Henkel that says that. Yes, our rights came long before we instituted government. Because isn't government instituted to secure these rights? We would have to have those rights in order to institute government. So this is more of the bar schmew, word salad, trying to convince us that they're the ones that are in charge, they're the rulers, they're the kings. No, you're the servant, period. Servants don't have that kind of power. None. Servants do not get to dictate to the people. They're masters. Because when you say servant, the reciprocal is master. It's master and servant. So if they're the servants, we're the masters. And therefore, at no time does a servant dictate to their masters what their emoluments are, what the scope and authority and their duties are to perform. Period. I mean, common sense here. Come on. Let's think about that. Don't think too hard, but, you know. All right, but we can continue reading here, and I'm going to show you what they don't want to say here, the history of the right. The development began in Powell v. Alabama. Oh, really? The development in 1932, it began in 1932, huh? Well, how in the hell did we have the right to the assistance of counsel with the Bill of Rights in 1790. What was it, 1789? 1791? I mean, come on. Think about it, people. Come on. 1932, in which the court set aside the convictions of 8 black unions sentenced to death in a hasty without benefit of counsel. Due process, Justice Elder said for the court, always requires the observance of certain fundamental personal rights associated with a hearing. Oh, wait, they're not constitutional rights now? And the right to the aid of counsel is of this fundamental character. Duh. This observation, what a great Captain Obvious, was about the right to retain counsel of one's choice and at one's expense, and included an eloquent statement of the necessity of counsel. The right to be heard would be, in many cases, of little avail if it did not comprehend the right to be heard by counsel. Even the intelligent and educated layman has small and sometimes no skill in the science of law. If charged with crimes, he is incapable, generally, of determining for himself whether the indictment is good or bad. Wait, you mean we're supposed to have indictments? Yes. Yes, we are. They're not supposed to be prosecuting by information. That's part of the Sixth Amendment, or Article the Sixth, is it not? Yeah. Actually, no, I believe it's the Fifth, pardon me. Left without the aid of counsel, he may be put on trial without a proper charge and convicted upon incompetent evidence or evidence irrelevant to the issues or otherwise inadmissible. There you go. Oh, he lacks both the skill and knowledge adequately to prepare his defense, even though he have a perfect one. He requires the guiding hand of counsel at every step in the proceedings against him. Without it, though, he be not guilty. He faces the danger of conviction because he does not know how to establish his innocence. But see, how do we establish our innocence when the burden of proof is on the moving party? And the alleged judge sitting there, the referee calling balls and strikes, is the one that's supposed to be ensuring that that doesn't happen. But they don't, do they? But see, right here, you know, they admit it clear in 1932 here. It is a certain fundamental personal right associated with the hearing and the right to the aid of counsel of this is a fundamental character. This observation was about the right to retain counsel of one's choice and at one's expense. So they're admitting that they know it's our choice to choose who our assistance of counsel is. What they're trying to do is license that right. They convert that right into a privilege. They take away the right to choose, liberty of conscience here, to choose for ourselves who our assistance of counsel is. But see, they're talking about here how they really can't figure out this stuff here and where the right came from and how this all works and blah, 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 blah. I just, you know, it just blows my mind when I find this stuff. Watch this. Well, let's see. Wait a minute. Let me show you this real quick. This is from the Founders Constitution. And this would be the debate in Massachusetts ratifying convention, 1788, January 30th, 1788. Oh, where was it? Was talking about being prosecuted by information right here. Let's see. The decision further said the gentleman has been said because the Constitution does not expressly provide an indictment by grand jury in criminal cases. Therefore, some officer under this government will be authorized to file informations and bring any man to jeopardy of his life, and indictment by grand jury will be disused. That's what they're doing today. Again. This is under discussion about the history of the 5th and 6th article of the Bill of Rights, articles, commonly known as 5th and 6th Amendment, but it is not. You can't be your own counsel. You're a man. You can speak on your own behalf. You don't have to represent yourself. Okay? That's they say it's represent, and it's actually represent through this gloss. It's fraud. Our names written in all capital letters. We sometimes, for the most part, for years have been calling it, well, that's the corporate fiction. No, actually, it's American Sign Language, and it's a fraud. It's not proper English. It's not even the English language. It's not any language. Really. But here they're talking about it. Oh, well, that's what they're doing. Now, this is what I pointed out to members of my team this week as we sat there and watched other cases. Oh, did you get this document entitled information? Would you like me to read it to you, or do you understand it? Hello? I mean, it's right in our face. They are actually prosecuting us by information. Therefore, some officer under this government will be authorized to file informations. And that is exactly what they're doing. There is no victim. This is a repeat of history, folks. We're right back here again. But watch this. Okay, all of this here is under the 5th and 6th. Okay? This is from the Founders Constitution books, which that Tony Pellegrino gave me, that actually came from Fred Kelly Grant. God rest his soul, was a good man, been in the law stuff for 60 years. But see, this is where it says, no person shall be held to answer for a capital or otherwise infamous crime. How many people know what an infamous crime is? That's right. Anything over 6 months jail time requires a grand jury indictment, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Now, what are we talking about in the militia? Why doesn't it say in the military? Because a militia, and a well-regulated militia, is what is necessary for the safety and security of a free state. Now, in order to have the organized militia, you still have to have the unorganized militia. Unorganized by government militia is every able-bodied male between the age of 18 to 64, automatically duty-bound to defend this nation from foreign and domestic enemies. It's a fact of law. It's a fact of our form of government, our Republican form of government, not the de facto English crown bullcrap. Now, again, what does it say here? Unless on a presentment or indictment of a grand jury. It has to be the grand jury that does this. Okay? Now, except in cases arising in the land or naval forces or in the militia when actual service time or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself. Well, isn't that what they're doing when they pull us over? You got some ID on you? Or anytime you're not even out on the streets and highways, they're always asking you, you got some ID on you? They're expecting you to pull out your driver's license. The problem is we're not required to have ID. They are. Public servants are required to have a state-issued picture ID with their name and official job title on it. That's so we know who they are. We're not required to have a picture ID. I mean, think about it, folks. What did we ever do before cameras? I mean, we didn't have cameras in 1776, right? Or did we? Did we have people who had picture IDs back then? No, we didn't. So we're supposed to have grand jury indictments. And just reading from history, talking about prosecutions by information. But right here, the body of liberties of the Massachusetts colony in New England, 1641. And remember what was just previously said, that they just couldn't find this. Well, did they read this? Every man that findeth himself unfit to plead his own cause in any court shall have liberty to employ any man against whom the court doeth not accept to help him, provided he give him no fee or reward for his pains. Well, imagine that. From 1641 in America, right there, that tells them to kick rocks. You don't have any say in who our assistance of counsel is. There's some history of the right to the assistance of counsel. So, I mean, that's pretty clear, even though it's, got that findeth himself e, you know. Why is there an e on the end of himself? Huh. Kind of like that policy. Oh, I'm going to, Jacqueline. I am most definitely putting this all together and sending it to them. As well as the one part that I was just reading from. So we go back down here. You guys are doing prosecution by information. This right here is a good read of what they were talking about back then. There is nothing to prevent Congress from passing laws which shall compel a man who is accused or suspected of a crime to furnish evidence against himself, and even from establishing laws which shall order the court to take the charge exhibited against a man for truth, unless he can furnish evidence of his innocence. Do you see what they were talking about back then? I mean, think about this, guys. Come on. Knowledge is power. We have to do some reading here, and here it is. This is what at the Revolution was going through in that era. But then what does he say? I do not pretend to say Congress will do this. But, sir, I undertake to say that Congress, according to the powers proposed to be given them by the Constitution, may do it. And if they do not, it will be owing entirely, I repeat it, it will be owing entirely to the goodness of the men, and not in the least degree owing to the goodness of the Constitution. Okay? The framers of our state constitution took particular care to prevent the general court from authorizing the judicial authority to issue a warrant against a man for a crime unless his being guilty of the crime was supported by oath or affirmation prior to the warrant being granted, and not by an officer of government. This goes back to basic Magna Carta due process of 1215, section 39. I mean, it's almost like they think we're so freaking stupid we can't read this for ourselves and comprehend this. I don't know about the rest of y'all, but I figured it out. Mr. Gore observed in reply to Mr. Holmes that it had been the uniform conduct of those in opposition to the proposed form of government to determine in every case where it was possible that the administrators thereof could do no wrong, that they would do so, although it were demonstrable that such wrong, excuse me, would be against their own honor and interest, and productive of no advantage to themselves. On this principle alone, had they determined that the trial by jury would be taken away in civil cases, when it had been clearly shown that no words could be adopted apt to the situation and customs of each state in this particular. Jurors are differently chosen in different states, and in point of qualification, the laws of the several states are very diverse, not less so in the causes and disputes which are entitled to trial by jury. What is the result of this? That the laws of Congress may and will be conformable to the local laws in this particular, although the Constitution could not make a universal rule equally applying to the custom and statutes of different states. Very few governments, certainly not this, can be interested in depriving the people of trial by jury. It's not a jury trial. It's a trial by a jury of our peers, of 12 men of our vicinage, as it is written in the Virginia Declaration of Rights, June 12, 1776. Let's see. Meum et tuum, whatever that. In criminal cases alone, are they interested to have the trial under their own control, and in such cases, the Constitution expressly stipulates for trial by jury. But then, says the gentleman from Rochester, Mr. Holmes, to the safety is construed to mean county, and the vicinity is construed. Well, I jumped a line. To the safety of life, it is indispensably necessary the trial of crimes should be in the vicinity, and the vicinity is construed to mean county. This is very incorrect, and gentlemen will see the impropriety by referring themselves to the different local divisions and districts of the several states. But rather, said the gentleman, just lost it. The idea that the jury coming from the neighborhood and knowing the character and circumstances of the party in trial is promotive of justice, on reflection will appear not founded in truth. So see what they're saying here is they actually wanted it, people that actually knew each other. This is why it's supposed to be of our peers, from our vicinage, from the vicinity, so that they could know the character and circumstances of the party in trial. And that's the way they started it out here. They wanted people to know so that the wool couldn't be pulled over their eyes. Although they did find where it brought in the possibility of not being impartial. So it worked two different ways, right? Like if you were to accuse an officer of government and sue them criminally, well, it would be a jury of their peers from their vicinage that knew him. And they would just say, nope, never mind, we're not going to find him guilty. So, the fact is they're talking about this here. Therefore, some officer under this government will be authorized to file informations. And again, I want to reiterate what we saw Monday as we waited there for Casey Baker's hearing and listen to this judge in these cases, talk about this document called information. Really? Not putting the two and two together here? Now, there's some other parts here I want to go to. There's the good one that I had up from Monday, right? That the jurisdiction of the Court of Admiralty be confined to maritime causes. I believe this might be the one of the ones. Well, I guess. I wonder if is it counsel or counsel? Let's see. Lots of those. Great. No. It depends on how that works, because yeah, it's okay. SEL, pardon me. Let's see if it's in there. Nope, it's not in this one. I'm going to save that because I didn't want to get rid of that. And of course, one of my favorite ones, Constitution of South Carolina, anal oppressive statutes have been passed or have been since enacted, by which the powers of admiralty courts in the colonies are extended beyond their ancient limits, and jurisdiction is given to such courts in cases similar to those in Great Britain are triable by jury. Now, let me see. Oh, there it is again in this one. So we got two different ones that say the same thing, right? All right, here. That in all prosecutions for criminal offenses, a man hath the right to be heard by himself and his counsel. Now, see, there it is, spelt COUNCIL, not SEL. So, as we can see, reading history here, they can't seem to find this right. That's because they don't want to. They don't want to tell the truth. They want to twist it so that it means something different than what it was originally intended to mean. But if we're going to sit here and talk about it in 1932, that the right to the assistance of counsel is our choice, and it's a fundamental right. This is fundamental. The whole fundamental principles behind being free and equal and having the liberty of conscience, the right to think for ourselves, that's religion. That's liberty of conscience, is religion. and the free exercise of it. Our own constitution, conscience. This is the Constitution for government, not for the people, not for those in the private. And again, Heil versus Henkel, right? Let's see. I know I have it here. I just thought maybe it would come up. You know, this, again, I highly recommend reading this case, Hale versus Henkel. This case is just loaded with stuff. And, you know, Boyd versus U.S. is in here. It's one of the leading cases regarding the Fourth Amendment, Article the Fourth. Right here. I wish I could move that up. I don't know how to get rid of that. Won't let me. Yeah. Anyways, this is where one of the key parts of this entire case is at. Now again, notice that it says if. So pay attention. If whenever an officer or employee of a corporation were summoned before a grand jury as a witness, he could refuse to produce the books and documents of such corporation upon the ground that they would incriminate the corporation itself. It would result in the failure of a large number of cases where the illegal combination was determinable only upon the examination of such papers. Conceding that the witness was an officer of the corporation under investigation and that he was entitled to assert the rights of corporation with respect to the production of its books and papers, we are of the opinion that there is a clear distinction in this particular between an individual and a corporation, and that the latter, the corporation, has no right to refuse to submit its books and papers for an examination to the suit of the state. The individual, now get this, I know, the individual may stand upon his constitutional rights as a citizen. Well, the problem is we don't really have constitutional rights. They're natural, God-given rights and civil rights that have been, created and laid down throughout they don't depend on the Constitution, but for all intents and purposes, we'll go with what's said here. The individual may stand upon his constitutional rights as citizens. He is entitled to carry on his private business. Whoa, wait a minute. Is there a private side and a public side? Yes, there most certainly is. We are entitled to carry on our private business in our own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to an investigation, so far as it may tend to criminate him. Duty to the state, since he receives nothing therefrom. Is there a stipend attached to some office here? Are we being subsidized by taxpayer dollars? Beyond the protection of his life and property. Let me repeat that. He owes no such duty to the state, since he receives nothing therefrom beyond the protection of his life and property. Here it is. This is the part I was talking about. His rights are such existed by the law of the land long and ascended to the organization of the state, which contradicts that they're constitutional rights, because those rights have to become before the Constitution. So they can't be constitutional rights when they're rights that came before the Constitution. I would say constitutionally protected rights would be more accurate. But look what it says. And can only, wrong mouse, only be taken from him by due process of law and in accordance with the Constitution, not the code, not even a statute. By due process of law is the process that is due. The common law dictates the process. Because there again, bills of rights and those merely declaratory of the common law. That is American Jurisprudence, Volume 16, Constitutional Law, Section 100. I believe that's the 2017 update. The last time I was down at the law library and got that. So bills of rights, and those specifically that are just merely declaratory of the common law, it's already the law. These bills of rights are just merely declaratory of them. Declare, clarify. D meaning down. So laying down the law is what we do with declarations, but we're clarifying it by writing it down. Okay? I see your comment there, Chris. Actually, I did see your email. Actually sent 2 different ones. I've just been extremely busy and a serious lack of time. I've got a couple of other people that would like me to as well. But I'll be honest, I'm pretty darn busy. Not that I'm declining. I will respond to your email. And that's Chris Rice out here on Facebook, by the way. So back to Hale versus Hinkle here, because on the other hand, right? Oh, let me finish this last part here. Can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are refusal to incriminate himself and the immunity of himself and his property from arrest or seizure, except under a warrant of the law. He owes nothing to the public, so long as he does not trespass upon their rights, because rights are the law, not the code. So, look at that. So, I'm familiar with what happens here when we say I don't answer any questions. I don't have to give you a driver's license, picture ID to any public servant on behalf of suit of the state. Period. And this is one of those cases that they really, really do not like. And I have used this case, and it shuts them down. Because look what it says. Upon the other hand, the corporation is a creature of the state. It is presumed to be incorporated for the benefit of the public. It receives certain special privileges and franchises and holds them subject to the laws of the state and the limitations of its charter. Its powers are limited by law. Those are bylaws. It can make no contract not authorized by its charter. Its right to act as a corporation are only preserved to it so long as it obeys the what? The laws of its creation. You'll hear me say this often. The law of creation. Where's your law of creation? I want to see the law of your creation of the corporation, because you have to obey the laws of your creation. So when we talk about city police, where is that in the Constitution? Where is that power delegated to create that? What process did you use to bring that into being? Because I can't seem to find that in there. But what I do find is no standing armies. No arm ye, armed bodies of men. And a militia is what is necessary for the security of a free state. The military. That's why the governors and the president are commanders in chief of the Army and the Navy or the Air Force or whatever. Okay? They're under admiralty jurisdiction. Military law. Governor. All of them, all public servants that are bound by the Constitution, Article 6, Clause 3, required. Legislative, executive, and judicial branch, both of the state and federal, are required to be bound by oath or affirmation to support this Constitution. That puts them under Article 3, Section 2. They're the ones under admiralty jurisdiction, not the people and not the people in the private. Now, here's one that, we've talked about for years right here. There is a reserved right in the legislature to investigate its contracts and find out whether it has exceeded its powers. It would be a strange anomaly to hold that a state, having chartered a corporation to make use of certain franchises, could not, in the exercise of its sovereignty, inquire how these franchises have been employed and whether they had been abused, and demand the production of the corporate books and papers for that purpose. The defense amounts to this, that an officer of a corporation which is charged with a criminal pay attention, criminal violation of the statute may plead the criminality of such corporation as a refusal to produce its books. To state this proposition is to answer it. While an individual may lawfully refuse to answer incriminating questions unless protected by an immunity statute, it does not follow that a corporation, vested with special privileges and franchises, may refuse to show its hand when charged with an abuse of such privileges. So, even at this reading in these de facto kangaroo courts, if they don't have jurisdiction to begin with, how in the heck are they going to try and tell me I can't be there as an assistance of counsel? But see, they don't use that words. They use, you can't represent anyone else because you're not licensed to represent someone else in the state of Idaho. Wrong diction, jackwagon. That's not what the 6th Article, the 6th says. It's not what it says as it is written. It says the right to the assistance of counsel, not to be represented by the member of a bar who has a membership card to practice your Sharia law code, bar code, because that's all it is. It's bar code. In Idaho, reading Peterson versus Peterson, the Idaho Code is not the law. Judge Eisman, 2014, Idaho Supreme Court, Peterson versus Peterson. Let me repeat that again. The Idaho Code is not the law. Why is it not the law? Because 3 members of the bar sitting on this code commission do not have any legislative authority. Because it has to say in the very beginning, be it enacted by the legislature of the state of Idaho, for it to even become valid in any way, shape, or form. But see, this is how we've been invaded and fundamentally altered our form, a Republican form of government. They've invaded our government, hijacked it. All these men holding them titles of nobility of esquire have invaded seats in government, in the legislature, the executive, and entirely taken over the judicial branch. And then we're all led down the road that, oh, well, we got to go to the judicial branch to deal with this. No, what's it say right here? There is a reserved right in the legislature to investigate its contracts and find out whether it has exceeded its powers. It would be a strange anomaly to hold that a state having chartered a corporation to make use of certain franchises could not, in the exercise of its sovereignty, inquire how these franchises had been employed and whether they had been abused, and demand the production of the corporate books and papers for that purpose, for a criminal charge, a criminal violation. Now, this is part where we go back into Section 10 of the Mason's Manual of Legislative Procedure, investigations by the legislature. It's in the rules of procedure. I mean, it's there. You know what? I'll just pull it up. I got it here somewhere. Let's see. It's in manuals, right? It's in our documents. Let's see. Yeah, here we go. Now I got to figure out which one is which. Which one? That's the 1953. Let's see. Of course. Come on. Okay, is it this one? I want the big one. There it is. Oh, yeah. Here's those 10 fundamental principles of group decision making. My favorite one right here. The group must have the authority to take the action it purports to take. Jurisdiction must be given, cannot be assumed. Groups sometimes assume powers they do not have. Number 9, there must be no fraud, trickery, or deception resulting in injury of another member. A person is entitled to the protection of the courts from inquiry through this injustice by a body making a group decision as in any other situation involving injury. That's called a declaratory judgment. That's it. Now, here's another one. To be valid, any action or decision of a body must not violate any applicable law or constitutional provision. The decision-making procedures of any body must comply with the applicable provision of any local, state, or federal law. It is governed by any statutory or court-made law, including provisions of constitutions and charters. Except for in our form of government, the judicial branch doesn't have the power to make law. Sorry. Okay, but we're going to go over here to section 10. Or I should say part 10. Like 7 something. We're getting there. Oh, this is it's part 7. So we got a little ways to go here. Right here. Right here. Oops, no. One more. There it is. Part 10, Investigations and Public Order. Now, this is in direct correlation to what it said there in Hale versus Henkel. It's right here. Investigations and Public Order. I know it might get really blurry getting this big. The right of a legislative body to make investigations. The right of a legislative body to make investigations in order to assist in its preparation of wise and timely laws, blah, 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 blah. The legislature has the power to investigate any subject regarding which it may desire information in connection with the proper discharge of its function, to enact, amend, or repeal statutes, or to perform any other act delegated to it by the Constitution. Ah, see how it's kind of a loophole-ish there? It's there. Any other act delegated to it by the Constitution. Oh, okay. We'll just move this around. I'm going to go over here to subsection 10, right there. An investigation into the management of the various institutions of the state and the departments of the state government is at all times a legitimate function of the legislature. And I'm going to reiterate, legislature, not the judicial, legislature. Chris and I have been telling the people, informing the people, and educating the people for 4 years. Legislature. The right to investigate any lawful matter is a right separate and distinct in each house and may be exercised through a committee. Not legal, lawful. So, there you have it. You know, it's funny that they would say this in the legislature in 1906 and we not even know. But yet, here it is in the Idaho Constitution. Specifically, you have to, correlate the words here, those right here. Certain special privileges and franchises. The laws of its creation? Huh. What does it say in Article 1, Section 2? Declaration of Rights. This is laying down the law for Idaho here. Political power inherent in the people. All political powers inherent in the people. Government is instituted for their equal protection and benefit. Well, wait. What? Beyond the protection of his life and property? Well, that's odd that Hale versus Hinkle would say the same thing that the law actually says, as it is written. And they have the right to alter, reform, or abolish the same whenever they may deem it necessary. Now, here's them. And no special privileges or immunities shall ever be granted that may not be altered, revoked, or repealed by the legislature. Huh. Why doesn't it say judicial there? Because it's the legislature that has that power. That's our court of justice. The judicial branch has courts of law, not courts of justice. The court of justice, where do we establish justice? In the legislature. Don't let them fool you and think that, oh, well, the judicial branch has courts of justice. Negative, liar. But there it is. His rights are such, existed in the law of the land, da, 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 da. Back down here. It receives certain special privileges and franchises. Special privileges or immunity shall ever be granted that may not be altered, revoked, or repealed by the legislature. Right? Yep, I know. I'm hearing you. I'm feeling it too. So, I hope we had a little bit of fun tonight. Exposing some more of the bar schmew and your lies, your trickery, your scheme, scam, and fraud of the bar. Yeah. I think it's time to alter, reform, or abolish certain things in my republic that doesn't belong there to begin with. And again, to right, to quote Edmund Burke, the only thing for evil men to prevail is for good men to do nothing. So who's with me? When are we gonna start doing something? When are we gonna do that? I know my team and I are about ready to drop it big. It's gonna get hammered out real soon. It is coming real quick. So buckle up, buckaroos, because we're coming. We're following due process of law. Your time is limited. Be advised. Usurpations of power, subversion of law, seditious conspiracy, domestic violence, internal insurrection, invasion, treason is a capital offense. And see, treason is giving aid to our enemies. This is why it's so important to comprehend and understand the Declaration of Independence. It's not just the document that declares our independence from Great Britain, because that's not that document. That would be the Lee's resolutions that separated us from Great Britain. Well, but then what is the Declaration of Independence? Declaring our independence from tyranny, from tyrants, from the monarchy form of government. A tyrant is our declared enemy. All of those, let these truths be submitted to a candid world, and is to be self-evident. But here we are having to write it down and clarify it, declare, Declaration of Independence. All of those facts submitted to a candid world are characteristics and conduct of our enemy, a tyrant. So when you start acting like what they're talking about, that's declared acts of a tyrant in the Declaration of Independence, you're giving aid to our enemy. That's why it's treason, because you're giving aid to a tyrant, our declared enemy. Okay? So I hope you all have a wonderful weekend. And if you'd like to help support the channels, you can send things over through the mail to the office at 6477 West Fairview Avenue, Boise, Idaho 83704. And that was Suite C, by the way, if I missed that. Otherwise, I do not have a digital way of doing things right now. I know a couple of people said they were going to try and get me some information on that. I haven't looked into the one per se, because it has to do with nonprofits. So anyway, greatly appreciate those that have sent some donations over there to the office. I greatly appreciate you. I want to thank my team. We're about ready to, oh man, I'm telling you folks, we're about to bust this out. I'm like starting to get excited. It's been long, hard, drawn out work. For 4 months, we've been working on this. Lots of documents as evidence of who did what, where, and when. We have it. And we could keep going down the rabbit hole, but we're at a point where it's time to file with what we've got and take this crap down. It's coming. I can promise you that. And yes, want to do a thank you to all the mothers out there. Happy Mother's Day this weekend. I'll be having some good times with my mom and my grandmother this weekend. We're going to have a family get together. So hope you all have a wonderful weekend. Enjoy your time. And again, want to thanks to the other team over here helping out, making this stuff happen behind the scenes over here, and the other part of the team behind the scenes that's not necessarily at the office all the time. So I greatly appreciate all of you, and thank you all for being here on Facebook and YouTube Mondays and Fridays. Thanks to all those on Patreon. Wednesday was a pretty good meeting over there. So again, trying to keep those limited to 2 hours on Wednesday night from 4 p.m. Pacific time, 5 p.m. Mountain time, 6 p.m. Central time, 8 p.m. Eastern time, and for 2 hours. Because I could just sit there and keep going and going and going and going, but I need a little bit of a break. I can't just, I've just burned myself out again. and I've been feeling it coming on. And I've been trying to get away, but I know it's coming. And once we get past this hump right here, gonna take a little bit of a break, and probably take a few days off and go up into the mountains and just relax. Not just an overnight camping. I'm talking like a few days, maybe like 4 or 5 days, maybe even a week. Just go up there and just turn my phone off, get away from everything, everybody, even my books. But hey, so, and yes, I am over on Patreon.com/Kirk's Law Corner. And don't forget over there on kirkslawcorner.com, if anything were to go down here, to get updated on where we'll be moving to. But I have this weird feeling that YouTube, Facebook, and Twitter are going to get hammered. Just a feeling, okay? Just my own personal feeling here. So I know nothing, but I have this weird feeling that they're going to get hammered real soon. But I could be wrong, right? So I do want to thank you again for all the likes, the follows, the shares on Facebook, the subscriptions over on YouTube, and the thumbs up on YouTube. Thank you all for being here. It means a lot to me to see, especially the reoccurring people. I know that you're trying. You want to be a part of this. You want to do something. And I thank you for being here and trying to learn and trying to do something. And it starts with knowledge. Knowledge is power. You don't have the knowledge, you ain't got no power. So I greatly appreciate you being here. And the regulars, I really see you. I see you all the time. Okay, I see you on here now. I know who you are. Mark, Joanne, Jacqueline, Karen. Let's see who's some of the other ones. Fix It Fast, of course. Justin Stanton, I see you on here every once in a while. Actually, you kind of bounce back and forth between Facebook and YouTube. But there's lots of people that I see on here on a regular basis. So again, thank you all for being here. Much love. And we'll see you on Monday for Monday Night Law on Kirk's Law Corner. Have a wonderful weekend. Happy Mother's Day. Much love. Good night, everybody. Love y'all.